Our intention is the court would allow us to have her enter the plea, do a PSI to kind of see where she is now. This was a case we brought over from CDC and then decide what is best on the motion. Either to dismiss
The
it
burglary
or
of a hab is the MTRP?
Yes, ma'am.
Okay, for some reason that's it. Before we go any further, I've got a note to remind myself, I have a seat in the jury box, I'm gonna get a drug test first. Hang on to it because it'll get mixed up with my other stuff. Please and thank you. Thank you. You don't want it to get lost in the abyss that I have going on up here. Ms. Cawthon, you have Zachary Turner.
Yes, Your Honor.
Good morning.
Good morning, Your Honor.
Morning, Mr. Coleman. Good morning, sir. You're Zachary Turner. And this is 24 DCCR 2197. Mr. Turner's charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, we're needing a reset. I've talked to the prosecutor and we're needing some more evidence.
There appears to be maybe some videos that did not make it to our file.
Okay,
And thereby not turned over to the defense counsel. And I'd like some time to run it in.
sure. All right, so I'll just do a normal reset. Mr. Turner, make sure you stay in touch with Ms. Cawthon. Once she gets that information from Mr. Coleman, you guys can meet and go over it, and then we'll see if we can get an announcement at the next court date. All right, thank you. You're free to go. Thanks, Ms.
Thank you, Your
Cawthon.
Honor.
Let's see, is Mr. Cole here? Mr. Leish? On Carly Davis? Carly Davis Hoosier. Is there, Mr. Coleman, witnesses on this or just argument?
And I forgot the message about the re-indictment. I'll just take care of that.
It's a mess.
It was.
I tried.
It was pretty convoluted.
All right, you're Carly Davis and Carly Hoosier. And this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that
In
one?
both cases, Judge.
Let me pull this up. I know I took a look at it last week, but.
This one's charged.
And so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. Well, it's working, it's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, it shows it expires October of this October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Mill Burn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
So where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except for 3 months. I go to his office now. I have an appointment today now.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes.
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving? Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay? So if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion, and it sounds like the court's read the motion, but, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI,
Right.
Judge. And that along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
Okay, thank you. See,
Diamond Jane.
Mr. Floyd? Is Mr. Floyd here? Mr. Choate, good morning. Good morning, Mr. Choate. This is Richard Afong Wade, 23-41318. Mr. Hoffpower, good morning.
Witness, please.
Good morning. You're Richard Afong Wade, and Mr. Afong Wade's case is set for trial to begin with jury selection next Monday. Again, what is everyone's announcement?
Unfortunately, we had to file a motion for continuance. Mr. Floyd had to have a partial knee replacement last Wednesday. He's under doctor's orders not to sit or stand for long periods of time. And so we had to file a motion for continuance. So I guess our announcement is not very much.
I got the message, Judge. I don't have an issue. I mean, I can't. He's got a medical issue.
Sure. Is there a timeline on that?
So in the next, I think he's got to follow up in 3 weeks, and then they'll reassess what he's allowed to do, right? Because like right now, he's still like at home.
Sure.
So,
Okay, so I'm going to reset the case to the next trial docket to give them plenty of time. Obviously, you guys know this was going to be the number one probably. It's really going to be up there next time. So as far as age goes, I'm going to set it, and if I need to protect everybody, I can do protection orders from other courts if you need that as well, because it'll be time to get it way past time next time.
yes, Judge.
Tell him I hope he gets better, and we'll see y'all the next trial docket.
Thank you, Judge.
You're
We
free to go.
appreciate it.
Thank you, Judge.
Mr. Franklin, you've got Ray No, two cases. Morning.
Good morning, Your Honor.
Good morning, sir. You're Ray No.
Yes, ma'am.
And in cause number 25 DCCR 0386 and 0387, Mr. No is charged with intoxication manslaughter and the other driving while intoxicated with a child under 15. And what is the announcement?
We are ready to proceed to trial by jury, Your Honor.
Okay, have y'all done a rejection? So what I'll hold it while y'all do. On the tablet, there's a plea bargain rejection. If y'all will get that signed with whatever has been offered that you're rejecting, and then I'll go over consequences, options, all of that, and then we'll get it on the trial docket.
Understood, Your Honor.
Okay.
Get that filed.
Yes, sir, thank you. I'll hold it while y'all get that taken care of. Is Dontrell Scott here? Mr. Scott, Mr. Johnson called earlier. He is not going to be able to be here. He's ill. I'm going to reset your case. You're free to go. Just stay in touch with Mr. Johnson in his office, and they'll let you know when you need to be back. Thank you, sir. Mr. Kelly?
Yes.
You've got Adam Moe.
He's present. Good morning.
Good morning. Good morning, you're Adam Moe? Okay, so we're here because Mr. Moe is on probation
Yes.
for I did a different type thing where Mr. Moe went and did some time on some of his cases
That's correct.
in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of links with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, because he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with
The
probation.
issue is, we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33, it isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me, so his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather. So
Right.
it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discretion of the court. I understand what probation is worried about.
Sure.
Set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and
I
the
don't want him
offenses
violated.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like that?
Correct.
Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No, see, he hasn't had his initial, actually, Ms. Simon is tomorrow. He just did intake and correct me if
Sure.
I'm wrong. He just did.
No, and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a there's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too, on the geography of this thing, Judge, is that if Adam were to make, I'm gonna call it a left turn if I've got the map correct in my head. If he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up for.
Judge, Ms. Roach says if he lived there when he sentenced him, he's grandfathered.
He's not, though. They specifically moved to
Okay,
thank you, though.
yes.
Ms. Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better, and,
Yes, ma'am.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one quick, I think there's not a school issue.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Mr. Burbank, Renisha Chason. Ms. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason. And will she waive the formal reading of the indictment?
She will, Your Honor.
And again, we're just going to get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
Okay. That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Ms. Chason is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well, and then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well,
When do I come?
it's about 5 or 6 weeks. Okay?
Maybe you excuse me.
Yes, thank you. Mr. Franklin, on Mr. No?
Yes, Your Honor.
All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Clause number 25, DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in clause number 25, DCCR 0387, you're charged with a state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I'm watching wrong on
Should be
that.
two.
It should be.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to
okay. I'm
redo it.
obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to.
should do it.
Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial, what your options are, and do you understand all of that?
Thanks for watching this courtroom
And do you want to
breakdown.
reject those offers?
Cases like this show how a single decision or a single mistake can completely change someone's future. We'd love to hear your opinion, so leave a comment below and let us know whether you think the judge made the right call. If you enjoyed this courtroom coverage, don't forget to like, subscribe, and turn on notifications so you never miss future hearings, sentencing updates, and real courtroom moments. And before you go, check out another video on the channel for more fascinating courtroom proceedings and legal analysis. Thanks for watching, and we'll see you in the next one.